What are we doing?
May I be on the issue of the jail to let the council know for today?
Before this hearing even gets rolling, you can already feel the tension building in this courtroom. What we're about to witness isn't just routine scheduling or procedural housekeeping. It's a chain of cases involving jail calls, alleged contact with victims, and accusations that defendants are trying to manipulate the system even while sitting behind bars. And that right there is where things get interesting. Because once someone is in custody, every call they make is monitored, recorded, and logged. Prosecutors often rely heavily on those recordings to prove whether a defendant is violating court orders or attempting to intimidate or influence victims. Now here's the critical point. When a court issues a no-contact order, it's not just a suggestion. It's a direct command from the judge. Violating that order can trigger serious consequences, including revoked phone privileges, bond revocation, or even additional criminal charges. And as we're about to hear, the prosecutor believes exactly that has happened here. According to the allegations, a defendant didn't just contact the victim. He may have gone a step further by involving another inmate to help him get around the restrictions. If that's true, that's a major red flag for the court. Judges take those kinds of workarounds extremely seriously. So as we move into the opening exchange between the attorneys and Judge Simpson, pay attention to the details of these jail calls. Because in many criminal cases, what defendants say on those recorded lines ends up becoming some of the most powerful evidence against them. And the big question for viewers watching this unfold is simple. If someone knows their calls are recorded, why risk making them at all?
You can, but what are we doing to pieces?
I was going to ask the court to please set this for exam. Your Honor, discovery is late at this time.
Misuse this to Ron.
Thank you, Your Honor. I downloaded a spreadsheet of defendants' jail calls and sent them to defense counsel, and then I downloaded the relevant jails and sent them to him so we get an opportunity to listen to them. I am requesting that the defendant's jail phone privileges be revoked. Since his arraignment, the defendant has contacted the victim 13 times. He actually had another defendant who's present today, we'll hear about him shortly, call the victim in this case and ask her for a different phone number. She provided that different phone number to other defendants that she otherwise doesn't know. And when I searched that different phone number in the jail call system, the only person to have ever called that number is Mr. Gates after that. So I'm requesting that his phone privileges be revoked. And I provided the jail calls to the defense.
Mr. Bernstein.
I have nothing to add.
Preliminary examination in this matter will be set in person. It will be set June 4th. Just the only thing holding him.
Yes, Your Honor, unless that other case got a bond on it.
June 4th, 2024, 9 a.m. before Judge Washington. Defendant's bond will continue, however, defendant's phone privileges are hereby ordered revoked.
And there it is, a swift and decisive ruling from Judge Simpson. The defendant's phone privileges are officially revoked. Now, to some viewers, that might sound like a minor punishment, but inside a jail environment, losing phone access is actually a significant restriction. For many inmates, those calls are their only regular connection to the outside world, family members, friends, and support systems. But from the judge's perspective, the reasoning is simple. If a privilege is used to violate a court order, the court removes that privilege. This also sends a message to every other defendant in the courtroom that day. Courts monitor jail calls very closely, and attempts to bypass restrictions, especially when victims are involved, will almost always backfire. Another interesting detail here is how quickly the judge ruled. That suggests the court found the prosecutor's explanation credible enough to act immediately without needing a lengthy hearing, and that raises a question worth asking. Do you think the judge made the right call here? If a defendant uses another inmate to contact a victim, should the court immediately cut off communication privileges? Because for Judge Simpson, the answer was clearly yes.
Assistant Public Defender Jay Bellinger on behalf of Ms. Barney. Ms. Barney, can you please state your name for the record?
Mary Barney.
Thank you. What are we doing? Oh, we're having a quarrel. Hold on. Are you guys done? I don't know what they're doing.
Okay. I apologize, Your Honor. She did. I'm still asking.
Might want
Okay,
to.
Your Honor, we were just asking for a 1-week adjournment in this matter.
Any objection from the people?
No objection.
Probable cause conference will be adjourned 1 week out is what? May 30th, 2024,
Thank you.
9 a.m. as bond, yes.
Thank you. This is a bit unique. Mr. Greenlee is president of the courtroom. He is the protected person. He's requesting me to review on. I'm not making this request, however, I'm noting it on the record. There is an ongoing NA case where DHHS has been ordered to facilitate 2 times a week parenting time for Ms. Barney through jail communication. I don't know for certain, but I believe that Mr. Greenlee is the person that is supposed to be facilitating that. He can't because of the no contact order. So I'm noting that for the record that his request is to be able to facilitate that parenting time.
And Your Honor, we would ask that the court grant that permission in order to do so. I don't have any of the paperwork in front of me just to support what the prosecutor is saying, certainly. However, I take her at her word and that is what's happened thus far. Would ask for the ability to communicate for that purpose.
I guess I'm not going to have much of a problem with it. I'm reluctant to order it at this point in time until I'm clear that's the way it's supposed to happen.
Understood.
Okay. So it's not that I'm saying no.
Okay.
I'm just not gonna change anything at this particular point in time because I just don't know.
Certainly, Your Honor.
Okay.
We
But
will.
if you get that paperwork, if there's no objection then from the people, then, or if there's an objection, then I'll deal with it.
Okay. Thank you.
And just to be specific, the NA paperwork that I had the opportunity to review says that DHHS is ordered to facilitate it. What we would then need is just whatever happens from there with CPS and DHHS, putting the burden on Mr. Greenlee because I don't have that.
Right, you don't have, right. I just need to know is he supposed to be involved in that process
Understood.
in order, all right?
Thank you.
Okay. Bond in this matter will continue. We'll see you next week. What are we doing?
All right, we are requesting adjournment for 2 weeks, so we may discuss a possible resolution.
Without objection, probable cause conference will be adjourned June 6, 2024, 9 a.m.
Okay. Thank you, Your Honor.
Bond continued. Thank you.
If possible, we would oh, you said bond continues?
You wanted to address bond?
Yes, Your Honor.
This is going to be long, isn't it? Go ahead.
I'm gonna try and keep it short.
Yeah, okay.
Client has a medical issue and advises that the client advises that the medical staff at the hospital he was taken to advises surgery. The medical issue isn't getting any better and would like the time to go and address this issue.
This is a very common defense request during pretrial detention, a motion to modify bond due to a medical condition. Essentially, the defense is arguing that the defendant should be released temporarily so they can undergo surgery or receive specialized treatment outside the jail. And legally speaking, courts absolutely do consider medical circumstances when making custody decisions. However, there's a key factor judges always weigh: whether the jail system can provide adequate medical care. If the facility or local sheriff's department can arrange hospital treatment or medical transport, judges typically prefer that route instead of releasing a defendant back into the community. Why? Because the court's primary responsibility is still public safety and ensuring the defendant returns to court. If a judge believes someone poses a risk of reoffending, intimidating witnesses, or violating conditions again, medical concerns alone may not justify a release. And you can already hear Judge Simpson hinting at that line of thinking. He expresses confidence that the sheriff's department can handle the medical situation. So the real legal question becomes this: is the medical need urgent enough to override the risks the court sees with releasing the defendant? As we're about to hear, the judge has already made up his mind.
So he would like me to, you'd like me to do what?
we would like to put our client on bond at this time so that our client may go address his medical issues with surgery.
Any response from the people?
There's a lack of specificity with respect to medical appointment surgery.
Get to. Got it.
Some concern, my other concern, the defendant has a pretty lengthy criminal history. DV convictions, resisting obstructing, and prior robbery convictions. Sentence that I can see in the Michigan Department of Corrections. And obviously, he has 2 cases of reported robbery.
Looking at everything, given the circumstances, if it involves certainly a medical issue, I trust that the Washington County Sheriff's Office will make sure that he is taken care of and that any issue that he has, he would be provided the proper medical care. The court doesn't see that as a reason to adjust his bond. Motion to modify defendant's bond is denied.
Thank you, Your Honor.
Bond will continue. Thank you.
Judge Simpson's response here is very direct. The request to modify bond is denied. What the judge is essentially saying is that the defendant's medical issue, while potentially serious, doesn't outweigh the court's concerns about keeping him in custody. Instead, the judge is placing responsibility on the county jail and local sheriff's office to ensure the defendant receives appropriate medical treatment while still detained. This type of ruling is extremely common in criminal courts. Unless the defense can show that the jail cannot provide necessary care, judges are reluctant to release someone solely for medical reasons. And from the court's perspective, that makes sense. If medical issues automatically led to release, it could create a loophole in the detention system. But it also highlights a difficult balance judges face, protecting a defendant's health while also protecting the public and maintaining the integrity of the case. And now the hearing moves forward to another defendant. But the drama inside this courtroom is far from over, because the next section of testimony will introduce even more serious allegations, including repeated calls to a victim and possible violations of court orders.
Name, sir?
Bruce Jones.
All right, what are we doing?
Your Honor, we would like to set this for preliminary exam, please and thank you.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 4th. Preliminary examination will be set in person June 4th, 2024, 9 a.m. That is before Judge Perry. Bond will continue.
Need to address is
Oh.
other tampering from the last date. I'll go with the phone privileges first. At the last hearing, I believe it was Ms. Rosso requested that his phone privileges be revoked. The defendant requested a hearing on that. After Your Honor then revoked his phone privileges, when the defendant went back to the jail that very same day after leaving your courtroom at 10:50 a.m., he got on the phone and called the victim and advised the victim that you had revoked his phone privileges, and then instructed the victim to download an app called Text Now. And he said, if they're going to take my phone privileges, I'm going to still call you, but another way.
This right here is the kind of moment that instantly grabs a judge's attention, and not in a good way for the defendant. According to the prosecutor, after leaving the courtroom where the judge had already revoked phone privileges, the defendant allegedly went back to jail and immediately made a call to the victim anyway. And the content of that call is what makes this situation particularly serious. The prosecutor claims the defendant told the victim that the judge had revoked his phone privileges and then instructed her to download an application called Text Now so they could continue communicating through an alternative number. If that's accurate, it suggests an intentional attempt to circumvent the court's order. Courts take these kinds of actions extremely seriously because they strike directly at the authority of the judge. A court order isn't just about the rule itself. It's about whether the defendant is willing to follow it. When a judge hears that someone might be actively trying to bypass restrictions, it raises immediate concerns about whether that person will obey any conditions of release moving forward. And this leads to a critical question for the audience. If someone is already trying to work around the rules while under supervision, can the court trust them to follow the rules outside of jail? That question is about to become central to what happens next.
And that was after Your Honor revoked his phone privileges. Since then, as far as I can see, his phone privileges have been revoked. But he did manage to get to the phone and make that call after the last hearing of before today. And then we still have the tether tampering, which is where community corrections received the notice that he was cutting his tether. They reached out to him. They asked him to take a picture of his tether to show them that he wasn't cutting it. He refused to do that, and then based on his location services that he was then leaving the area that he was in. He was arrested. The tether has a clear cut mark on it, and he told community corrections that his dog was chewing on it.
Now the situation escalates even further. The prosecutor is introducing another allegation: tether tampering. For viewers unfamiliar with this term, a tether is an electronic monitoring device typically worn around the ankle. Courts use it to track a defendant's location while they're out on bond. It's a way to allow someone conditional freedom while still maintaining supervision. But if that tether is damaged or removed, it raises a huge red flag. According to the prosecutor, community corrections received an alert suggesting the device had been tampered with. When they asked the defendant to send a photo to verify the tether's condition, he allegedly refused. And when authorities later examined the device, they reportedly found a clear cut mark on it. The explanation offered that the defendant's dog chewed through it. Now, judges hear all kinds of explanations in courtrooms, some believable, some less so. And when it comes to electronic monitoring, courts are usually very skeptical of damage claims unless there's clear proof. Because if someone intentionally cuts a tether, that signals an attempt to escape supervision. So the prosecutor is stacking multiple concerns here: possible no-contact violations, jail call manipulation, and now alleged tampering with monitoring equipment. And from a judge's standpoint, that combination can drastically change how risky a defendant appears.
So at this point, I'm requesting that Your Honor continue to deny his bond, which was denied after the tether tampering situation, and I'm asking that Your Honor continue the revocation of home privileges.
Any response?
What was that court date for Judge Perry, real quick? I need help.
Before.
Thank you, Your Honor. Four. Your Honor, I'm going to leave that to the court. My client wants to focus more on the preliminary exam and deal with the case at hand, Judge.
He's waiving the hearing on the phone issue?
Yes, Your Honor.
All right. And the court will order that his phone privileges are revoked, as they previously had. And so this bond will continue in all other aspects as revoked.
Thank you, Your Honor.
Thank you.
Public Defender Natalie Pate with and on behalf of Mr. Fainer, who is approaching.
Your name?
Christopher Fainer.
Thank you. What are we doing?
Your Honor, at this time, we wish to set this for exam.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 4th. Preliminary examination in person will be set June 4th, 2024, 9 a.m. before Judge Washington. Bond will continue. Okay. Yep, sure.
I'm trying to figure out when to say it, and I don't.
No, it's okay. Okay.
I have kind of two options to my request, please. One is I'm requesting that his original bond be ordered at $200,000 cash. That is the request that we made at the time we charged it, and my position is that his bond should have been set at based on the facts of this case. In the alternative, I'm asking that Your Honor revoke the defendant's bond and remand him today for his bond violations. So I'll start with the bond violations, perhaps. After the defendant was arrested and in custody, and after he was arrested, he made 86 attempted calls to the victim, and 23 of those calls were completed. I had the opportunity to download a PDF and send that to defense counsel, as well as download the 23 completed calls. I did also accidentally download some of the incompleted calls and sent those her way as well. But she's had access to them since yesterday, which is when I discovered them. I have not had the opportunity to listen to the content of all of the 23 completed calls. Of the calls that I was able to listen to, I was able to listen to the defendant talking to the victim about arranging his on posted, arranging his pickup at a gas station near the jail. The two of them talking about how to get the no contact order dropped, about how they can have contact with each other once. So I'm requesting that his bond be revoked and that he not be permitted phone privileges in the jail for those violations. In regard to, and I should also note in terms of the jail phone calls, this is the defendant from Mr. Gates' case earlier when I mentioned that he had another defendant from the jail call and asked his victim for another phone call.
The other number?
Yes, this is Mr. Faker is the person that participated in that, and he's the one that called her victim. Or excuse me, Mr. Gates' victim. So in regard.
So he called the victim in the other case to get a new phone number so that that defendant could contact that victim.
Correct. Thank you, Your Honor.
At this point in the hearing, the prosecutor shifts from procedural violations to the actual facts of the underlying case. And what's being described is extremely serious. According to the allegations, the defendant was intoxicated while driving with children in the vehicle. An 8-year-old child reportedly told police that the defendant threatened to crash the car and kill everyone inside. If proven true, that alone could form the basis for several criminal charges, including child endangerment and reckless driving. But the allegations go even further. The victim claims that during the drive, the defendant struck her and began choking her while operating the vehicle. That's an incredibly dangerous scenario, not just for the victim, but for every passenger on the road. And when they arrived home, the violence allegedly continued. Witness statements from the victim's parents reportedly describe seeing the defendant with the victim in a chokehold before she was thrown to the ground. These kinds of allegations fall into what many courts categorize as high-lethality domestic violence indicators, particularly strangulation. In domestic violence research, strangulation is often treated as a major warning sign because it significantly increases the risk of future serious harm. So when the judge listens to these facts, he's not just evaluating a single incident. He's evaluating the potential danger level involved.
In regard to the facts of this case, the defendant, I'll kind of jump to the end and then go back through it. The defendant at the end of this admits to the police that he was intoxicated while driving the vehicle. While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast, and then when they got home, she watched as he was choking her mom. The victim is that child's mom, who reported to the police that in the car, the defendant decided to begin an argument with her, calling her a psychopath, saying to him that she could not take his guns away from him, that he hit her in the head while he was driving, and actually while he was still driving the vehicle began to strangle her. While the victim reported separately from the interview with the child, reported that the defendant told her while he was driving the car that he was going to crash the car, kill them all, and that it would be her fault. He said that with children in the car, and that the 8-year-old subsequently cooperating that. As I mentioned earlier, he had consumed alcohol and he later admitted to the police that he was intoxicated at the time of driving that vehicle. In the vehicle, put both of his hands around the victim's neck and strangled her. She couldn't breathe. At a stop sign, the victim tried to get out of the car to flee, but the defendant sped off. Once they were home, inside the home, both of her parents were present and her parents were interviewed separately. The victim told the police that the defendant choked her and threw her to the ground. The victim's father, who was present, said that he walked in and he saw the defendant with the victim in a chokehold, that he said, "What the F," except he actually swore, "Are you doing?" And the defendant immediately released her, throwing her to the ground. The mom also was interviewed separately. She said that she saw the victim push the defendant and that the defendant then put his hand on the victim's throat and began pushing her by her neck, and that the mom then left the room and did not see what else happened. The police observed redness on the victim's neck, a V shape. They put in the report as a blood blister near her trachea. And those are the injuries they observed occur. So just based on the facts alone of this case, I am reviewing my office's response to cash surveys, that would have been the appropriate bond to set at the time. However, if your honor is inclined to, frankly, I'm asking that you just revoke bond completely, set him a bond, remand him for these jail calls and contact he's had with the victim agreement, and order that he not be permitted to use the phones in the jail. Thank you, Your Honor.
Response.
Thank you, Your Honor. Our ultimate request is to keep bond set as where it is. As to the allegations of this case, I will just point out they still are allegations, and upon review of discovery.
Now we hear the defense perspective, and it's important to remember that in criminal court, allegations are not the same as proof. The defense attorney is reminding the judge of exactly that. From their standpoint, the police report contains claims that have not yet been tested in court. The defense argues that some of the information in the report may be inaccurate and that the defendant denies committing the alleged criminal acts. That's a critical part of the legal process. At this stage, the court isn't determining guilt or innocence. Instead, the judge is deciding whether the defendant should remain free on bond or be held in custody while the case proceeds. The defense also introduces another key factor: the defendant's personal background. They mention that he has steady employment as a construction foreman and is supporting 5 children. In bond hearings, judges often consider these types of details because they can indicate whether a defendant has strong ties to the community. Stable work, family responsibilities, and a history of appearing in court can sometimes weigh in favor of allowing someone to remain out on bond, but the judge still has to balance that against the seriousness of the allegations and the alleged violations of court orders. And that balancing act is about to reach its conclusion.
My client does maintain that a lot of what is in the report is incorrect. As to the jail calls, that is correct. Ms. Hughes did.
A lot or all?
Well, some of the identifying information would be correct in the report, but the allegations that would be criminal, my client denies. As to the jail phone calls, that is correct. Ms. Hughes did provide me with both the log and a folder with the calls in them yesterday afternoon. I have had the opportunity to review the log. However, I have not reviewed the substance of the calls in their entirety. I would acknowledge that some of the calls were made to the complaint witness's number and arraignment. However, to my understanding, there are no allegations of any other bond violations, either contact or otherwise, since my client's released from the Washtenaw County Jail.
What about his participation to facilitate another individual violating their bond condition?
The first I'm hearing of that is today, Your Honor. So I can't speak as to that whatsoever. I am asking the court to keep the bond set as where it is. Mr. Fainer has been out for, I believe, how long have you been out since posting your bond?
Last week, Thursday.
Last week, Thursday, so exactly 1 week, Your Honor. To my understanding, in that week, he has not had contact with the complaining witness nor violated his bond in any other way. We are asking for it to stay as is so he continues showing up to court, and he has been very active in the defense for this case. He is a foreman for a construction company and does have full-time work providing for his 5 young children. We are asking the court to keep bond where it is at this time.
Well, I don't know why the bond was set on those facts. Is he on a tether?
Yes, Your Honor.
Given the facts of this case, or at least as they're related to the court, I believe that the bond as set is an abuse of discretion. Everything that's mentioned is high-lethality.
Judge Simpson's language here tells you everything you need to know about how he views this situation. When a judge uses the phrase high lethality, they're referencing a category of domestic violence cases where the risk of serious injury or death is considered extremely elevated. Strangulation allegations, threats to kill, intoxicated driving with children in the car, these are all factors that courts treat as major warning signs. But what really concerns the judge here is not just the alleged violence, it's the pattern of behavior after the arrest. He points out that the defendant allegedly continued making contact that wasn't supposed to happen, even facilitating another inmate violating their own bond conditions. From the court's perspective, that behavior suggests a willingness to ignore court orders entirely. And once a judge believes someone cannot follow the rules of release, The next step becomes very likely: bond revocation. Because if the court can't trust a defendant to comply with conditions outside of jail, the judge may decide the safest option is to keep that person in custody until trial.
The alleged victim in this case ended up at least going to the hospital to tend to wounds that she is alleging were caused by the defendant. Moreover, then that after all of this occurs, and what causes the court a great concern as to the defendant's conduct is that there are these contacts that aren't supposed to be contacts while he's in the jail, that then also then while he's in the jail, and I don't have any reason to dispute it because I had to revoke that other individual's phone privileges. He facilitates, not only does he violate a condition of his bond, he then facilitates another inmate violate the bond in the case or in the other case. Not going to happen. It's just simple. I think the bond initially was set wrong. His behavior since then would lead this court to believe that the defendant cannot conduct himself reasonably, would also then pose a danger not only to the community, but to this particular victim and to the community as a whole. Defendant's bond, and he hasn't complied with the bond as we've said it, Mr. Allen. Defendant's bond is hereby ordered revoked. His phone privileges are also ordered revoked. Defendant is remanded.
And with that final statement, the court makes its decision. The defendant's bond is officially revoked, and his phone privileges remain revoked as well. That means the defendant will now remain in custody while the case moves forward through the legal system. Judge Simpson's reasoning is clear. He believes the original bond may have been set too low given the seriousness of the allegations, and the defendant's conduct since then, particularly the alleged jail calls and attempts to bypass restrictions, convinced the court that he cannot be trusted to follow bond conditions. In many criminal cases, this is a turning point. Once bond is revoked, the defendant loses the freedom they previously had while awaiting trial. But it's important to remember that the case itself is still ongoing. The defendant is still presumed innocent until proven guilty in court. What this ruling reflects is the judge's determination about risk and compliance, not final guilt. And cases like this often raise difficult questions for viewers watching from the outside. How should courts balance the presumption of innocence with public safety concerns? When allegations involve violence and violations of court orders, where should judges draw the line? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.